Welcome to the Brief Encounters series. We're here today to talk about the proposed Sunshine Act of 2022 in DC, and that concerns court secrecy that hides information from consumers. That proposed act was introduced by Council Member Mary Che with broad co-sponsorship. I'm Don Resnikoff. I'm active with the DC Bar communities and the DC Consumer Rights Coalition. Our goal today is to provide information to the public and to lawyers, and the focus is on why law reform is needed to deal with the problem of court orders permitting secrecy about dangerous products. Our goal is education rather than principally lobbying activity. We defer on lobbying activity to groups like the National Consumers League and Public Justice. I'm here today with Naomi Claxton. She is a consumer advocate and a new board member of the DC Consumer Rights Coalition. She is a former steering committee member of the DC Bar's Consumer and Antitrust Steering Committee. She's going to discuss with us the reasons and background of the Che Act, and more specifically, how the act could affect the local Washingtonians. Good afternoon, Naomi.
Good afternoon, Don.
To begin with, let's start with this. Could you give us an overview about the Che bill? What are its purposes? How will it achieve them? And how does it relate to pre-existing law?
Good question. I've read and studied the bill. The bill that was introduced is specifically modeled on legislation that has currently been introduced in California. It has already been adopted in states such as Florida, Louisiana, Virginia, Arkansas, and Washington. The bill is consistent with pre-existing law. So the United States Supreme Court has expressly recognized that there is a common law right to inspect and copy public records and documents, and this includes judicial records and documents. This holding came from Nixon v. Warner Communications, which was decided in 1978. In that case, the court indicated this right includes a presumption in favor of public access to judicial records.
What are your thoughts about how litigation can affect consumers when courts permit information about dangerous products to be kept secret?
The language in the bill's introduction is very informative on this and strongly suggests that it was geared towards preventing specifically what happened during the opioid crisis and in other cases where information about dangerous products was kept secret for a long period of time. Councilwoman Che's notes on the bill explain that lawsuits were brought alleging that certain opioids were far more addictive than disclosed. And yet, through aggressive legal maneuvering, the pharmaceutical companies were able to enter into confidential settlements and got court orders that sealed evidence of the addictiveness of painkillers such as OxyContin, Vicodin, and Dilaudid. The result is what we saw over a decade of overprescription of highly addictive substances that created a generation of addicts, the opioid epidemic as we now know it. And when the substances were finally more stringently regulated, which happened more than a decade after their dangers were known to pharmaceutical companies, street drugs like fentanyl, a synthetic opioid that can be mixed with anything from marijuana to methamphetamines, and heroin stepped in. The truth is, the opioid epidemic did not have to be what it was, but we keep coming back to the same principle in issue after issue, case after case.
As an aside, I'll mention I've been reading a book by Patrick O'Keefe called Empire of Pain. And it's pretty unflattering to the owners of the OxyContin company, Purdue Pharma. I know that there are other cases where confidential settlements were important and kept information away from the public. Now, we have time limitations, I'm aware of that. And so there's only so much we can say about those additional cases. But would you say a little bit more about some of those other cases, Assure, thalidomide, Takata rather, and any others that come to your mind now?
Absolutely. Most of us of a certain age have heard of the thalidomide babies. That case was 60 years ago. It's the poster child of what happens when companies are permitted to gatekeep information about serious product defects in litigation and settlements. But more recently, we have products such as Assure, which is a Bayer product. It was a supposedly safe, metallic, non surgical form of birth control. Unfortunately, it had metal coils that dislodged or broke inside women, leaving shards within the reproductive system with dire consequences. Bayer began to sell that product in 2002. We now know that Bayer knew how dangerous it was in 2008, but Essure was not even taken off of the market until 2018. Over 27,000 lawsuits were filed alleging harms such as miscarriages, perforated organs, hysterectomies, and more. And yet Bayer was permitted to self select over 97.7% of documents in the lawsuit to be covered by a broad protective order that prevented others from appreciating the danger of the product. I mean, in this case, tens of thousands of patients suffered serious injury. There were 23 reported deaths, and there were over 67,000 reports of Essure failing in women. In the end, over objection, after they disclosed about 900,000 documents, only 200 of those documents have been released to the public. There's also the Monsanto Roundup case, another case where the manufacturer knew that the product was carcinogenic as early as 1999. Over 8,000 plaintiffs have filed lawsuits alleging claims in state and federal court around the country. And yet in 2017, a federal judge signed a blanket protective order again, permitting Monsanto, the wrongdoer here, to self select which documents they would permit to be made public. In this case, Roundup is still on the market. There are janitors, agricultural workers, landscape, and others who are exposed to it on a daily basis. The bulk of the documents that were subject to discovery remain under seal and are simply not available. Monsanto has even gone as far as to have its own scientists ghostwrite scientific studies about the safety of the carcinogenic ingredients in scientific journals. And Roundup remains a hazard because of the numbers of deaths and illnesses that have remained shrouded in mystery. There is nothing to guarantee to a traditional consumer that the product that's on the market is safe today. There are so many other cases, both large and small, including recently the Takata airbag cases. If you have a Honda or an Acura, even Takata had over 90% of the market share for airbags. The Volkswagen water pump cases and others, these cases affected consumers nationwide. That includes consumers right here in the district. I know my husband drives an Accord. His car was not fixed under this recall until 2017.
So we can see that this problem of court secrecy of consumer information is broad and serious. And moving from that to what are going to be the effects of laws like the Sunshine Act, and specifically, how would laws like the Sunshine Act aid consumer efforts to avoid dangerous products and take action about them?
In truth, as noted above, there's ample evidence that in many cases, not just with opioids, consumers have become aware early and have brought lawsuits that might have rung the alarm and saved lives if the information about the dangerous product were made available to the public and not kept secret. As mentioned before, we saw this in Bayer Assure. We saw it decades ago in the thalidomide litigation. We're seeing it going on right now. And the right of the public to access to judicial records, and that's what I spoke about as being the holding in the Nixon case from 1978, was specifically applied by the DC Circuit in the District of Columbia in a case called Johnson versus Southeast Community Hospital. There, the DC Circuit stated that a district court should weigh certain factors in determining whether and to what extent a party's interest in privacy or confidentiality of the court judicial process outweighs the strong presumption in favor of the public access to judicial records. But the factors that were delineated included: one, the need for public access to the documents; two, the extent to which the public had access to the documents prior to the sealing order; three, the fact that a party has objected to disclosure and the identity of that party; four, the strengths of the property and privacy interests involved; five, the possibility of prejudice to those opposing disclosure; and six, the purposes for which the documents were introduced. And the reason that I laid those factors out is what we are seeing is that in many cases, the effect of the judicial process has been to permit defense attorneys to dangle settlement in front of plaintiffs contingent on their agreement that the settlement be confidential and subject to a protective order in litigation. That is to say, when the parties go to the court and submit a signed settlement agreement, they are also submitting an order stating that the court shall seal certain documents by stipulation of the parties. And what has happened is the vast weight of the factors that the court should consider is being outweighed by number three, the fact that no party has objected to disclosure of the documents. The Sunshine Act intends to try to block that practice.
So the idea is that these factors that are important to a court are present in pre-existing law, but the Sunshine Act and acts like that will affect the absence really of an affected party and try to ensure that the factors will get applied in a way that helps the consumers. Is that a correct understanding of what's happening?
Absolutely. So, without overstating, if a court was actually looking at the Johnson factor, specifically factor number one, the need for public access to the documents at issue, most, if not all, of the examples above would not have resulted in a seal so broad that in many cases it even restricts access to the complaint. The reason the Sunshine Acts are so necessary is that they will restore balance, not just for consumers, but for regulators who are often in the best position to rectify these issues before they become epidemics.
Let me ask you this. Why is it that plaintiff attorneys representing consumers ever agree with defendants' attorneys representing the manufacturers that information about dangerous products should ever be kept secret?
Well, the bottom line is that plaintiffs rarely have pockets as deep or even the will to continue litigating. And the reason that that matters is because we have to look at the practical effects of stipulation. Because the plaintiff in that case is not representing a class of persons. The plaintiff is not representing a city, state, or municipality. They're representing themselves. And of the cases discussed above, actually none of them. I was going to say only the Volkswagen water pump cases, but I believe there may have been a fatality as well. Each one of them resulted in the loss of health, livelihoods, and lives, and often on a very wide scale. These are things that a money judgment can't replace. And typically, for a consumer or a member of the public to get any statistically significant relief, they'd have to bring their own lawsuit, which is expensive, time consuming, and to be perfectly honest, nearly impossible to get going against a defendant like Pfizer or Bayer. Class action lawsuits and to a large extent, consumer protection suits brought by government agencies very rarely return anything of substance to individual victims. And this includes consumer protection cases where the government is specifically seeking restitution. The problem is the vast number of claims simply outweighs the available relief. This also matters because the cases above were huge. They impacted tens of thousands in some cases, and in others, millions of consumers. These are not the only cases where judges are permitting this type of conduct, failing to evaluate all of the factors and evaluating whether the fact that a party wants the document sealed, and in truth, permitting the stipulation to secrecy, which implicates factor number four, to be the determining factor. This matters because when issues that affect environmental hazards or large product safety are discovered and addressed early, whether this happens through a regulator, a consumer protection office, or even a plaintiff's lawyer, in a way which meaningful light is shed on the issue, generally speaking, there's enough to compensate victims because there are far fewer victims.
Now, in recapitulating, what it is the Sunshine Act and acts like it are going to do to help consumers, I think it'd be useful to focus particularly on the effect on consumers in Washington, D.C. How will D.C. consumers be affected favorably if the Sunshine Act is adopted?
Well, for one, in each of the cases mentioned above, there were victims in the district. On another note, as written, the law states that the court may not enter by any order, stipulation, or otherwise any order that has the effect of restricting the public's disclosure of a public hazard. And what that means is that the court may not enter an order, a protective order that restricts public disclosure of anything that is a covered civil action. And so this is any civil action that involves, and it's defined in the act, a defective product or an environmental condition that is likely to cause significant harm and to allow members of the public to challenge agreements and orders that violate this act. While I think the covered civil actions are rather vaguely defined, I think that in conjunction with the factors in Johnson, the courts are going to have a far stronger rubric for evaluating when a settlement may be confidential. And more importantly, when they may or must unseal a complaint or deny a protective order, even over the objection of the defendant or even the parties. What this means is that in DC, as in other jurisdictions that have enacted sunshine laws, consumers simply have a better ability to get information about what's happened in other cases with persons who are similarly situated. In the law, that means people who have suffered the same type of harm. And this allows them to understand what's happening to them and the type of relief they can expect. But most importantly, it raises the incentive of companies and corporations that find out about significant product defects or environmental incidents to act quickly to remediate the issue and settle with the affected consumers instead of covering, concealing, and confidentially settling with anyone who sues.
So it seems that in terms of access to justice for consumers, the ability to know information that might have otherwise have been kept secret so that they can go to court and get redress seems to be quite important. I'd like to turn to the question of what defendants' attorneys, attorneys for manufacturers, might say about the Sunshine Act and acts that are like it. In particularly, the defendant attorneys express concerns that loss of secrecy will unfairly affect trade secrets, confidential government processes, personal information of a party, or other interests that legitimately should be kept secret.
So the Sunshine Act, again, is modeled on legislation in other jurisdictions. In DC, we already require redaction of personal identifying information. And the Sunshine Act is written, provides that the court must redact PII, trade secrets, and the amount of any financial settlement. Now, we as attorneys know that the idea of a trade secret or confidential company process is something that's going to be subject to interpretation. I think there probably will be a lot of litigation about what that actually means. But I think, in all fairness, that cannot mean an effect on the consumer.
I see. Now, another possible defendant-oriented point would be whether laws like the Sunshine Act will raise prices for consumers and make litigation more expensive by making settlements less likely. Can you offer a comment on that?
This is always a concern, right? But I believe it depends on the situation. And in cases like these, where there's a significant public health or environmental concern that could affect thousands or even millions of consumers, the risks outweigh the benefits of early disclosure. But, Don, before we go forward, I wanted to discuss one matter that I neglected to hit on the settlement terms. The terms of the settlement, and this is one of the most important things, especially when you're dealing with government oversight, regulatory or consumer protection lawsuits. Agreement terms are very informative, and under the Sunshine Act, the settlement terms do not have to be redacted. And where there has been injunctive relief, where the court has ordered the defendant to do something or to cease doing something as a result of the settlement or judgment, this is something that should not automatically be subject to an order of protection. And under the Sunshine Act, I believe these should be disclosed whenever there is a covered civil action. The specific terms, injunctive terms of the agreement should be public. I do want to go back to the question that you raised about whether the law would raise prices for consumers or increase the cost of litigation. I think that the sooner the public knows, the sooner the situation can be resolved, the fewer the casualties. Now, that is always the goal in consumer protection: information, injunction, restitution. Ensuring that the public has information is the first step. Acts like the Sunshine Act are a wonderful step on the path to transparency in the types of cases that cause the most widespread societal harms. And so, do I believe that the Sunshine Act will raise prices for consumers or increase the cost of litigation? I think that that's a case by case, but I believe that the goal of the act and the way that it is applied matter.
In conclusion, I think it would be useful if you provide just a brief summary or a closing statement about what the problem is and why laws like Sunshine Act will alleviate the problems for the consumer.
Well, we won't say alleviate, but we will say educate. So the Sunshine Act will allow the court to refuse to seal and refuse to provide protective orders in cases where there is a covered civil action. And those are defined as specifically any civil litigation that involves a defective product or an environmental condition that could cause significant harm. And what this would do is allow members of the public to challenge an agreement or an order that would violate the act. I believe that this would have the result of reducing the broad protective orders that we see in so many cases that prevent consumers, regulators, and consumer protection organizations from appreciating the level of harm that is caused by certain environmental conditions and certain defective products. And that it would affect DC consumers simply the same way that it has affected consumers in other jurisdictions by giving them access to the information that allows them to make informed decisions to protect themselves and their families. This decreases the cost of litigation because it decreases consumer harm.
Well, I think you've given us and the audience, a very good introduction to the issues that are involved on secrecy in court litigation. Other groups like the National Consumers League and Public Justice, I'm sure will be heard from in coming weeks and months as advocates for this bill. And of course, I think we'll also hear from defendant-oriented interests as well. But I thank you very much for this contribution to the discussion.
Thank you so much for having me, Don, and I've enjoyed our conversation.